Okay, peace to the gods, peace to the gods. Isabel here. Got a good show today for you. I want you to start also checking the schedule on my YouTube channel because I'm going to be coming on every day at the same time. I'm already preloading all the shows. I'm thinking it's going to be 1 o'clock. I'm kind of ambivalent about the time right now, but I think 1 o'clock is a pretty good time right now. Today, I'm going to go over statutory terms because what I'm trying to do is I'm trying to get people clear in their mind on the difference between public and private. Now, this is a class that I normally would conduct on SBC University, but today I decided to kind of do it on YouTube and share it with you. So you got to get a sense of how we conduct our classes on SBC University, as well as the material that we go over. Understanding statutory terms was something that I discovered because I had this understanding of the separation of public and private. What individuals have to understand is this: public and private does not mix. When you mix the two, any private matters that you bring into the public are going to be reinterpreted according to statutory terms. The ideal and public versus private, where we're talking about this state citizenship, American state national, all these different terms that people like to use, that you're supposed to be conducting that in the private. And most of these people don't understand that point. They think that they can exercise a private right under a public regulatory system. And you just can't do that. They're mixing public and private. And that is the problem with 99% of what is going on in that space. And so today I'm going to kind of help you a little bit in getting an understanding. We're going to start with the terms that are being used that can actually trigger a statutory jurisdiction. I would appreciate it if you like the video also to get the analytics up. We're going to get right into it. Okay, so here today, it's called the language trap, why certain words automatically trigger statutory construction and how to avoid it. Now, the core principle, the one most people miss: courts do not begin analysis by asking, what did the party intend? They begin by asking, what legal category does the language place the activity in? And this is also true in any contract that you write, any type of documentation where the definition is on a statute. You shouldn't be using it at all. You shouldn't be using any. And I'll give you, I'm going to tell you what did this, how I went down this pathway. I saw people were using the terminology fund to trust. And I was like, where did they get this term fund to trust from? And then I went to an attorney website, and that's the verbiage that they use. On the private side with private trust, we don't use the term fund to trust. We don't use that term at all. I had a mentor. We used exchange or exchanger. All right. That's what keeps it on the private side. The verbiage that you use is going to bring it into the public. We don't say fund. I wasn't taught. I've been doing this for 15 years and I never was taught to say fund to trust. So I'm going to at least share all that with you out there. Because you copying, what's happening is they're copying attorneys and the verbiage that they use. And attorneys don't know anything, most of them, about how to put together a private trust. They know how to put together a statutory trust. And they're going to use verbiage in there that's going to trigger statutory jurisdiction. So let's keep going. Okay, once again, what's the core principle? The one most people miss. Here's the core principle behind everything dealing with this terminology. Courts do not begin analysis by asking, what did the party intend? They begin by asking, what legal category does the language place the activity in? They're looking at the language that is being presented to them on all the paperwork that's before them. That categorization step determines which body of law applies, which presumptions attach, which burdens shift, and which remedies are even available. Okay, law is very structured, and that structure, it's very precision. And man, when you really understand it, you will really begin to appreciate how they set everything up. How when something comes from the private into the public, how it's reinterpreted through statute. And this is what we say on SBC University, that when you learn proper trust administration, somewhere you're not learning it anywhere else on the internet. Ain't nobody else teaching it like we're doing it on SBC University. Proper private trust administration. You begin to understand that by reading a lot of down case law and having a good mentor. They're not reading any case law. Matter of fact, some of them don't even understand what case law is. You have some of them saying case law is not the law. the most idiotic shit I've ever heard. But once again, they categorize you first. By your verbiage is going to place you in a certain category or a certain capacity. This is what the person does. The person establishes what capacity, and that capacity determines what rights and liabilities are going to be attached to that capacity, which it can be a result of your conduct or some other amalgamation or nexus that attaches you to the public jurisdiction. So once a court places an arrangement, so look at that. What legal category does the language place the activity in? That categorization step determines which body of law applies, which presumptions attach, and which burdens shift, which remedies are even available. Once a court places an argument inside a statutory category, common law principles stop controlling unless the statute expressly allows them to. Soon as they obtain, and I've read this in so many different case law, I don't know why people go in and say, you don't have jurisdiction over me. Once a jurisdiction is obtained, it's not relinquished to the termination of the suit. You might as well stop saying that especially if the case has been going on and you keep coming in and talking about you haven't proven jurisdiction, you're just wasting your breath, man. Just find another route, okay? So once a court places an arrangement inside a statutory category, common law principles stop controlling unless the statute expressly allows it. This is why word choice is jurisdictional, not stylistic. Word choice is jurisdictional, not stylistic. Very important. Okay, 2, what statutory construction? Okay. What statutory construction actually means plain English? Statutory construction is the judicial process of interpreting words defined by statute, applying legislative intent, and enforcing regulatory schemes. Once a court engages in statutory construction, private intent becomes secondary, freedom of contract narrows, and equitable discretion shrinks. But we meant it differently becomes legally irrelevant. You're no longer arguing law, you're arguing compliance. All right, and this is something that you have to understand. I'm going to repeat it again. Public and private doesn't mix. If you want a private remedy, it doesn't need to be in the public. This is something I was taught in the beginning, but I got caught up in all these people talking about challenging jurisdiction. I just got taken away with this shit. And from day one, Creditors and Bonds teaches that specifically. You don't put those arguments on the record. These are private remedies, and public and private don't mix. Let's keep going. How words become jurisdictional triggers. Certain words are not neutral. They are legal switches. When a court sees them, it does not treat them as ordinary English. It treats them as terms of art. All right, so we're going to look at some words you use. When you use the word fund, what the court hears is a regulated pooled capital, obviously subject to regulation. When you use the word investor, what the court hears is a protected statutory participant. Words to use: contribution, capital subject to oversight. When you use the term return or yield, investment expectation. When you use the term manager, fiduciary under statute. When you use the term account, custodial relationship. When you use the term portfolio, securities aggregation. When you use the term compliance, regulatory submission. All of these terms have a statutory definition, and when you use them, you have automatically triggered statutory jurisdiction. Once these appear, the court does not ask whether a statute applies, it asks which one. The judge is not even thinking when they see these words if a statute applies. They're looking to find out which statute applies, not if a statute applies. The label lens lock-in effect. This is the sequence that traps people. Number 1, the label. The drafter uses a familiar or casual term like fund, investor, or return. You have a lot of people who draft these or try to teach trust and always talking about trust, and they like to use these terms. Now, If your indenture agreement ever comes under some sort of dispute and you have to take it to an equity court, okay, unless you have the definitions in your document, but I wouldn't even use these words because they all have a statutory definition attached to them. The judge is going to construe it through a statutory lens. The court selects a statutory analytical framework associated with that term. The lock-in. From that point forward, statutory definitions control, case law interpreting the statute controls, and common law arguments are filtered out. This is why courts routinely say, regardless of how the parties characterize the arrangement, by the time that sentence appears, the damage is already done. By the time you hear a judge say, regardless of how the parties characterize this arrangement, what they're telling you is that we're going to interpret it according to the terminology that's being used, and these are clearly defined and narrowly defined according to statute. Why courts reclassify even private agreements? Okay, you can have a private agreement and they were reclassified. Now, let me give you an example of this because we just went over this in a trust case. This goes to form versus substance, and I hope that you will at least take the time to Google these terms I'm saying. Form versus substance as it relates to a private trust. Okay, the IRS doesn't care whether you have a private trust or a public trust. That is not what they are evaluating as it relates to taxes. It don't even have anything to do with it. They're looking at the activity that is being engaged in by the trust and whether that not that's a regulatory activity or not. Also, if you use terminology in your indenture agreement, your trust can get reclassified. An example, you claim that you have a unincorporated business organization. However, you placed terminology within the indenture agreement that allows it to be reclassified, which gave power of the beneficiaries to exercise control over the trustees. And that's being reclassified as an association or a partnership, regardless of the formation of it, the form that you have. For tax purposes, it's being reclassified. This is the importance of proper drafting, as well as the importance of proper administration as it relates to trust. We have trust class tomorrow, 9 p.m. Central Standard Time, only on SBC University. All right, so number 5, why courts reclassify even private agreements. Courts are institutionally trained to protect the public, enforce legislative schemes, and prevent circumvention. They're not going to allow you to circumvent the statute because they have to protect the public at all costs. I don't know how many maxims of law I've read that say this, even to the point if they have to disregard the law, if it's going to in some way materially affect the public. That's why none of these y'all coming into court trying to do private set-offs is not going to work on the record. That's a private matter. That's not a public matter. So when language resembles a regulated category, courts assume the statute was meant to apply. Private parties cannot opt out by semantics, and private does not defeat public policy. And that's another thing. A lot of people in these echo chambers seem to believe that privacy trumps public when it's the other way around. Public trumps private. Okay, you got to learn how to maintain privacy. I have a class that we're conducting tonight on that, where we're going to get into how the Constitution protects privacy and the different articles in there. And we're going to go through each one of those tonight on SBC University. This is especially true in areas involving money, pooled value. Okay, so when language resembles a regulated category, courts assume the statute was meant to apply. Private parties cannot opt out by semantics, and private does not defeat public policy. This is especially true in areas involving money, pooled value, deferred benefits, or fiduciary relationships, which is why financial vocabulary is the most dangerous vocabulary of all. Using financial vocabulary is one of the quickest ways to trigger a statutory jurisdiction. The rule of thumb is if it's defined in a statute, you shouldn't even use it. We're going to get to that. We're going to get to that. The common law alternative private ordering vocabulary. Now, you should know I'm the first one to come on the scene with this term. It's called private ordering. I want you to Google that term right now because I want you to make it a part of your vocabulary, especially if you're following me. It's called private ordering. Private ordering is what you are supposed to be using if you consider yourself to be private or in the private. That is the label. That is the term. Private ordering. Google it right now and familiarize yourself with it. Common law does not operate on categories like fund or investment vehicle. You want to invoke the common law, but you're not using common law terminology. It operates on persons, capacity, consideration, exchange, breach, and remedy. All right, so let's look at some statutory common law alternatives. Okay, instead of using the word fund, we're going to use the word exchange. Remember I told you it's called an exchanger. Called an exchanger, that's what I was brought up. All the common law information I got to teach me trust there's nothing in there that's talking about funding a trust. When I first heard that, I got another show and everybody was talking about, it's fund. I'm like, what is this word fund to trust y'all keep saying? So let's look at these words real quick. All right, so you got, in the statutory world, you got the word fund. In the common law world, we have exchange. As I said, you see me on other videos, I say, man, we use the word exchange or man, in exchange. Because that's what happens in the common law. Everything is an exchange, like money of exchange. It's not no fund or anything like that. That's investment terminology. That's regulatory terminology. When you're trying to invest to make money, you're trying to get a profit or a gain. Investor is an exchanger. Contribution is consideration. That's a contractual term. Return, we use the word allocation. Manager, we use the word contracting party. Compliance, we use the word performance. And regulation, we use the word enforcement. So on the left side are all the terms that they use that invoke a statutory jurisdiction. On the right side are all the terms that you should be utilizing whenever you are drafting any of your documentation or anything where you don't want to trigger statutory jurisdiction, especially as it relates to anything in a trust. This is not wordplay. This is forum control, because you're going to control the forum based off of the terminology that you use. If you use any statutory terminology, a statutory forum is going to control. Why economic reality still depends on language. Courts often say they look to economic reality, but economic reality is interpreted through language. Judges do not observe reality directly. They see pleadings, contracts, trust instruments, and labels chosen by the drafter. Language determines what facts matter, what tests apply, and what questions are asked. If the words sound like Wall Street, the court applies Wall Street law. The irreversibility problem. One of the most dangerous aspects of statutory triggering is this. Once statutory construction begins, you cannot argue your way back into the common law. And I don't know how many case law I've read where it says that you can go to your local law library and find it in your state, that once statutory jurisdiction is obtained, they won't relinquish it to the termination of the suit. How many times people been following me years ago, been hearing me say that over the years? I mean, I've been saying it over the years. You cannot say we didn't mean fund You can't say I didn't mean fund. They're not really investors. You can't say that. They're not really investors, but investors in your documentation. But you want to come on the mic now in open court and say, well, we weren't really talking about investors. This is private. You're going to call it private, but you're using statutory terminology. Because the court's response is always, then why did you use statutory language? This is why prevention, not litigation, is the real defense. Public and private don't mix. Okay, drafting jurisdictional engineering. Drafting as jurisdictional engineering. SPC doctrine. At SPC University, drafting is not treated as documentation. It is treated as jurisdictional engineering. Every word must answer, number one, what body of law does this invoke? Number two, what capacity does this assign? And number three, what remedies does this unlock or foreclose? This is all begins with the terminology that you use. You got to understand what capacity is. Okay, you know, when you invoke a body of law, there's a certain person that is attached. You know, another thing we got to get rid of is this demonization of the word person. A person is a device that the public uses to attach liability and duties in the public when someone engages in a public regulatory activity. If you don't want to be subjected to that, then you have to understand how to maintain privacy. And that's under private ordering. Under private ordering. Private ordering is, if you're interested in privacy in any capacity whatsoever, that's all you need to be studying. Private ordering. That's where you should constrain your studies to. Contracts, trust, private member associations, unincorporated private associations. That's it. You need to be constrained to that. Every activity that a private trust engages in is done through a contract. Everything. Contract, let me tell you something, and this is why we're doing it tonight. Our superpower is the ability to contract unlimited, as it was talking in Hale versus Hinkle. Article 1, Section 10, the contract clause is the clause that defends. It's some other ones in there too, but that defends the private. And that's what you got to utilize. You got to utilize contracts. Contract makes the law. Contract is how you enforce your rights. You just don't have rights by default. Rights are not recognized. Private rights are not recognized in the public arena. They're going to get, if you have to bring a private matter into the public, it's going to get reinterpreted through statute. You're supposed to be resolving private matters privately. Public and private does not mix. At SPC University, drafting is not treated as documentation. It is treated as jurisdictional engineering. Every word must answer, number one, what body of law does this invoke? Number two, what capacity does this assign? And number three, what remedies does this unlock or foreclose? Each person breaks down into a certain capacity. Like, for instance, a trustee is a person, but that also has a certain capacity associated with that type of person. An employee is a type of person, and there's a certain capacity that is associated with that type of person. That capacity is going to dictate what remedies are going to be either made available or denied. If a word invites statutory interpretation, it does not belong in a private agreement, instrument. Let me repeat that again. If a word invites statutory interpretation, it does not belong in a private instrument. Let me say it again. If a word invites statutory interpretation, it does not belong in a private agreement. The SPC, the SPC master rule. This is the one to teach. Never use a word that requires a statute to explain it if your objective is to remain in common law. Never use a word that requires a statute to explain it. That's simple enough. Public and private don't mix. Don't use anything. Don't use their terminology in the public. This single rule eliminates 80% of reclassification risk, 90% of amateur drafting errors, and nearly all guru-induced litigation disasters. Just by being vigilant and circumspect of the kind of terminology you're using. Courts do not punish intent. They enforce categories. Categories are triggered by words. Statutory words invite statutory control, and common law survives only where statutory language never enters. All right, so I got 50 terms. Yes, I got a whole bunch for you. I did this video should hit 1 million views. But I know it won't because so many of y'all, there's just so much hate out there and y'all don't want to share anything or anything like that. But this is the kind of video that should do 2 million views. It should do 2 million views, easy. This right here I'm about to show you is so important. Rule: if a word requires a statute to define it, it does not belong in private common law instrument. Okay, so first we're going to go through financial triggers. We already did this. Fund, we're going to use exchange arrangement. Trust fund, we're going to use trust raise, describe, not label. Investment, we're going to use private exchange. Investor is exchanger. Capital contribution is consideration. Return is allocation. Yield is contractual outcome. Profit, you're going to use surplus only if tied to performance. Rate of return, contractual benefit. Portfolio, schedule of assets. Anybody who studies private trust, we're familiar with all those terms on the right side. We use it in all our stuff. Fiduciary regulatory triggers. Oh man, I think did I take one? Okay, it's B right here. All right. I don't know. I got it mixed up. I turned around. B, securities offering triggers. Subscription, we're going to use private agreement. Units, we're going to use interest. Described narrowly. We're going to describe it too. You're going to be specific. Shares, beneficial interest, non-transferable. Offering, private transaction. Prospectus, disclosure statement. Issuer, contracting party. Placement, exchange. Accredited, qualified by agreement. Security, contractual interest. Instrument, financial sense, we're going to use agreement because that's what negotiable instruments are. They're contracts. They're agreements. That's what they are. We use that term. Use agreements. So here's our fiduciary regulatory triggers. If you use manager, you're going to use administrative trustee. Fund manager, we're going to use trustee with limited powers. Custodian, we're going to use holder pursuant to trust. Account, we're going to use ledger or record. Compliance, we're going to use performance. Regulation, we're going to use government by instrument. Oversight, internal review. Reporting, we're going to use notice. Audit, we're going to use the word inspection. And regulatory, we're going to use the word contractual. All right, let's look at the employment agency triggers. Employee, we're going to use the word independent party. Compensation, we're going to use the word consideration. Salary, we're going to use the word periodic allocation. Bonus, we're going to use the word conditional allocation. Agent, we're going to use authorized party, limited. Principal, we're going to use contracting party. Duty, in a statutory sense, we're going to use the word obligation. Benefit plan, we're going to use the word private agreement. Plan administrator, we're going to use the word trustee. And payroll, we're going to use the word distribution schedule. Let's look at tax and public finance triggers. Income, we're going to use the word receipt. Revenue, we're going to use the word gross receipts. Deduction, we're going to use the word adjustment. Expense, we're going to use the word disbursement. Taxable, we're going to use the word character determined by law. We're going to use that term. Exempt, we're going to use the word not characterized herein. This is the language you're going to take and replace. If you got any of this language in any of your documentation, you're going to take it out and you're going to replace it with what's on the right side. Withholding, we're going to replace it with reservation. Filing, we're going to replace it with notice. And treasury, we're going to replace it with depository. And public, non-private, avoid entirely. Avoid the word public at all costs. Non-private. If you feel more professional using the statutory word, that's exactly why it's dangerous. If you feel like using those statutory terms sound more professional, that's exactly why it's dangerous. Side-by-side annotated trust clause rewrite. Statutory triggering version. Do not use. This is what you don't use in your trust indenture agreement. You take it out right now if you have it in any trust documentation. Statutory triggering version, do not use. The trustee shall manage the fund, accept capital contributions from investors, and deploy assets to generate returns for the beneficiaries. The trustee shall maintain accounts and provide reporting as required. Why this fails? Fund is pool capital presumption. Investors is securities analysis. Returns is profit expectation. And account/reporting is regulatory posture. A judge must now ask, what statute governs this? Here's the SPC SAFE common law version from SPC University. The trustee shall administer the trust res in accordance with this instrument. Parties engaging with this trust do so as exchangors, providing consideration pursuant to private agreements. Any allocations are determined by contractual performance and not derived from pooled investment activity. Records are maintained solely for internal trust administration. Why this survives, and we read case law all the time, every day, every Tuesday and Thursday, we read case law. Why this survives: no pooled capital language, no passive parties, no profit expectation framing, and no regulatory vocabulary. A judge now asks, what did the parties agree to? Contract now makes the law. This is the entire game. This is how you control, own nothing, control everything, because now you're in control because your language did not subject you to statutory interpretation. Public and private do not mix. Judge-facing essay, why private ordering collapses when statutory terms appear. Once again, if you just joined us, private ordering, if you consider yourself to be private, that is the only thing you should be studying. Google the term right now and start circulating it. Private ordering. Why private ordering collapses when statutory terms appear. The judicial starting point. Courts do not approach disputes philosophically. They approach them categorically. The first question is never, is this private? It's always, what body of law governs the category of activity? And once again, the courts don't ever even, these statutory administrative courts that you're going into, they are enforcement arms for the state. They don't even consider anything private. It's not even in their mindset. If you go and read administrative law with American jurisprudence, right there in the first or second paragraph, it tells you that the purpose is the enforcement of private rights, not the vindication of the enforcement of public policy, not the vindication of private rights. Public and private do not mix. When you go in those courts, they interpret everything through statute. They tell you that. They say this is a statutory jurisdiction. The admiralty is not that it is admiralty. It's in the nature of admiralty, because that's what they borrowed from, because the common law was too slow to facilitate commerce. Y'all can go and research this. Admiralty fitted the bill, but they don't have cognizance over admiralty. What they did was they borrowed the procedural mechanisms of admiralty and placed them within this statutory jurisdiction. That's why it's called colorable admiralty jurisdiction. Please stop calling it an admiralty jurisdiction. That is ignorant. And you're just giving them further ammunition to try to discredit what you're saying. Once again, the judicial starting point. Courts do not approach dispute philosophically. They approach, they approach them categorically. The first question is never, is this private? It is always, what body of law governs this category of activity? Categories are identified by language. Statutory terms are jurisdictional invitations. When parties use statutory terms of art, courts are institutionally obliged to, number one, apply legislative intent. Number two, enforce regulatory schemes. And number three, prevent private circumvention. At that point, freedom of contract yields to public policy. Private ordering does not fail because courts dislike it. It fails because the drafter invited public law in. It ain't the courts don't respect you privately. It's that you ignorant and you using the wrong terminology. The irreversibility doctrine, practical, not formal. Once statutory construction begins, intent becomes irrelevant, disclaimers lose force, and relabeling is ignored. Courts consistently hold that parties made a contract around statutes whose vocabulary they themselves invoked. Equity is not going to allow you to do that. This is not punishment, it is classification discipline. Why exchange language preserves common law. Common law governs persons in capacity, exchanging consideration, and enforcing obligations. It does not govern funds, investors, pooled capital, and regulated financial products. When a trust speaks the language of exchange, courts respond with the law of exchange. Somebody out there got y'all saying fund to trust. You need to come to class so you can understand how your drafting it's called form versus substance. Okay. A trust can be materially affected by the verbiage that is used in the indenture agreement as well as the activities of the trustees. But you definitely don't want any language in there that will allow the courts to reclassify your trust as an association or a partnership for tax purposes, or dissolve it altogether because now it's masquerading as a trust. They call it a sham trust. Bench conclusion. Private ordering collapses not because it is disfavored, but because statutory language converts private conduct into public concern. Avoidance is not achieved by disclaimers, but by drafting discipline. You put a disclaimer in there all you want to, and then in the body of your documentation, you got this statutory language. Public and private does not mix. They don't ever mix them. Make sure you don't either. Foundational doctrine, SPC doctrine chapter. Language is jurisdiction. Chapter thesis. Jurisdiction is not asserted only by governments. It is conceded by drafters through language. Core principles. Number 1, words precede analysis. Number 2, analysis determines forum. Number 3, forum determines remedies. And number 4, remedies determine outcomes. This is all very structured how they have it. This is the information that you need when you come into the public. But I'm going to tell you this. You're really supposed to stay out of the courts. You're not even supposed to be going in there. But it's not that. See, this is where the echo chambers get it wrong. They think they can declare privacy and then still conduct their affairs the way they always have. And then just go in the courtroom and declare I'm private, I'm a state citizen. That's not how it works. All of law is based off of the maxim, actions speak louder than words. Y'all can Google it, use ChatGPT, pull it up. You're not going to create your own maxim of law, or you're going to dictate how things are going to go in the public. I don't care how smart a guy sounds in an echo chamber. The SPC hierarchy: language, category, capacity, forum, remedy. Write that down. Everything begins with the language that you use. Language determines category. Category determines capacity. Capacity determines the form, and form is going to determine the remedy that's available to you. It's all scientific. Law is scientific. Once you understand that, this appeals to the analytical mind as well. Once you understand how the formulas and how it's structured, then you can approach it intelligently instead of haphazardly, throwing shit up against the wall, hoping it works. Let that stay on the screen. I hope y'all taking notes. I hope you're taking notes. This is very valuable, what you're getting right now. You're not getting this on any other channel on YouTube. Nowhere. And this is just a small example of what we have at SPC University. Very small, just very small. The SPC hierarchy: language equals category, category equals capacity, and capacity equals form, and form gives you a remedy. If language is wrong, every downstream step is lost. It all begins with language. You're not recovering from the use of bad language. You're not recovering from the use of bad drafting. Our thing is contracts and trust. You got to know how to put together contracts, and you got to know the correct terminology and verbiage to use in a contract so you don't invoke or trip a statutory jurisdiction. Some sort of statutory trigger. These are statutory triggers. SPC Master Drafting Rule restated. Never use a word that requires statutory construction unless you are prepared to be governed by a statute. Let me say it again. Never use a word that requires statutory construction unless you are prepared to be governed by statute. Why this matters. Most litigation loses losses attributed to corruption, bias, or unfair judges. That's what they say in the echo chambers. They love that. Oh, the judge is corrupt. The judge is biased. The judge is unfair. Like I said, they will never stop and pause and even consider that they may be wrong. That's why they terrorists. That's why. They mad, angry. But the only thing they should be angry at is their own ignorance. These are actually self-inflicted classification errors. SPC's value is not in fighting the system. It's in never triggering the system you don't want. Final teaching line. Courts don't strip rights. Drafters waive them one word at a time. You have the right to remain silent. Anything you say can and will be used against you. Hope y'all enjoyed that. That's just a small example of what we do at SBC University. Our classes are a lot longer than this, though. I usually go 2 or 3 hours. We have a lot of engagement within the classes. Yes, you are allowed to ask questions, a lot of questions. Yes, we do a lot of engagement. Yes, we do a lot of review. One thing I like to do is read a trust case and then allow the class to discuss the case, because usually it's very interesting and very engaging. And then from that, then we do a review of the principles that were used and see how well people did in their assessment of it, why the judge ruled in this particular way. You're going to find out this is all very scientific. And these jurisdictional things, everybody wants to challenge jurisdiction. Well, you need to pull that back in, and you got to start with the language that is being used. I just gave you 50 terms on here. There's a lot more to it than all of this, but I just gave you 50 terms. Go back to your indenture agreements and review them and see how many of those terms you've been using, or in your contracts, or in your pleadings, or any of the documentation you've been using. The era of regurgitation is over. We are in a new age. A lot of the errors we have are going to be cleared up now. We're going to get clarity on everything, how we should be approaching the courts, how to conduct ourselves privately, how to respect the public, and how to get the public to respect the private. Where is this republic? What is freedom, and where is it located at? We have the answers on SBC University. So we have classes Monday through Thursday from 9 p.m. Central Standard Time. I did it at that time because we have people on the West Coast. It's 7 o'clock their time. They're off of work. And then people on the East Coast, it's about 10 o'clock. But a lot of people come. It's growing. It's almost doubled in size. I guess the word is spreading. That we do things differently in SBC University. We're taking it very slow, and we are deconstructing everything about this brick by brick. I'm looking at all the information that we've been told in the last 30 years. I've been systematically breaking it down and retaining what was good and throwing out what was bad. But a lot of the bad comes from a lack of understanding what we just read right here, as well as this distinction and this interplay between public and private. That is the foundation of the majority of the problems in this space. The majority of the problem, and not a clear understanding of what constitutes public and what constitutes private, and what powers you can exercise in the public and what powers you can exercise in the private, and what constitutes a public activity as opposed to a private activity. And I can tell you, operating a motor vehicle, no matter how you want to classify it as commercial or something, it doesn't fall under that. It falls under public safety and the inherent rights of the police powers of the state. That's what it invokes every time you get on the public road. So you classifying it as commercial doesn't mean anything. But you've been told that for 30 years. I was told that. I used to focus on it. But that's the wrong focus. That's the wrong focus. So with that being said, like, comment, and subscribe below the video. I will answer all the questions below the video. If you'd like to come out and join us, it's $99 a month. $99, you get what? You get 16 classes a month, 16 for $99. Get 16 classes a month. All right. So I don't know where you're going to get that, anywhere, what school you're going to get that. The reason I do that, because I really enjoy teaching. And, I just like coming on. I've been reinvigorated with all the knowledge that has come upon me. I've made a sense of a lot of things that I didn't have clarity on. Now I have clarity on. And I'm sharing it with all of you. And I think that it's very empowering, and it's challenging as well. Because see, here's the thing about the private side. The private side requires you to do everything yourself. It requires you to do, the public is not doing anything for you. So it requires accountability and responsibility. Anyway. Peace to the gods. I'll see y'all tomorrow. Tomorrow has something else for you tomorrow. We're going to talk about, is it all a tax tomorrow? It's all a tax. We're going to have a discussion about that tomorrow. Is it really all a tax? And we're going to understand how taxation applies and how you can avoid taxes. The difference between tax evasion and tax avoidance. That's a public and private play as well. That's a public and private play. Tax evasion and tax avoidance. I'll see you tomorrow. Peace to the gods.